Well, there is a third way for changing the text of the constitution that shall not be deemed as an amendment to the constitution under Article 360. Like say for example, what you do under Article 2 and 3, Article 4 declares they are not amendment to the constitution. Similarly, what you do under Article 169 when you abolish or when you create the second chamber of the state legislature, it means the legislative council, that is also not considered as a constitutional amendment. You can introduce the bill either in Lok Sabha or Rajya Sabha. You must get it passed in both the houses separately by a special majority. If federal features, ratification by simple majority by at least 1/2 of the states. Then comes to the president. When it is presented to the president, president must give his assent. No provision of joint sitting as far as constitutional amendment bill are concerned. Let us move now to the amendment of the Indian Constitution. And I told you in the last class that amendment of the Indian Constitution, it can happen in two ways. Now, what is the procedure of amendment? It is prescribed under Article 368. A bill needs to be introduced in the Parliament. A constitutional bill which seeks to amend the provisions of the Constitution can be introduced in either house of the Parliament. It means it can be introduced either in Lok Sabha or it can be introduced either in the Rajya Sabha. In each house, it has to be passed by a special majority. Special majority means majority of not less than 2/3 of the members present and voting, which again has to be a majority of the total membership of the house. Total membership here means the total number of seats in the house, irrespective of either there is any disqualification or vacancies. It means absolute majority. We are not talking about effective majority. Absolute majority plus there must be at least 2/3 of the members present and voting saying yes to the changes being proposed under the Constitution Amendment Bill. Once it is passed by both the houses, it goes to the President. But if the Constitution Amendment Bill is seeking to amend some of the federal features of the Constitution, then that bill will also need ratification by at least 1/2 of the states. States means those territories which enjoy federal relations with the Union. It means the Union of India, those that comprise the Union of India. At least 1/2 of them should say yes. No majority has been prescribed that how they would ratify the Constitution Amendment Bill. So therefore, it is considered that simple majority would be enough. Second, no time limit has been prescribed that within what time limit they have to give their ratification. Do you understand this? That is amendment to the Constitution. Well, there is a third way for changing the text of the Constitution that shall not be deemed as an amendment to the Constitution under Article 368. Like say for example, what you do under Article 2 and 3, Article 4 declares they are not amendment to the Constitution. Similarly, what you do under Article 169 when you abolish or when you create the second chamber of the state legislature, it means the legislative council, that is also not considered as a constitutional amendment. So again, para 5 of 5th schedule, 6th schedule, again these are not considered as constitutional amendment. So this is what you need to keep in mind. So I'm saying that what is the procedure of amendment? Let's have a look at it. An amendment of the Constitution can be initiated only by the introduction of a bill for the purpose in either house of the Parliament and not in the state legislatures, obviously. It can only start from the Union legislature. A constitutional amendment bill can be introduced only in Lok Sabha. Correct statement? No. It can be introduced either in Lok Sabha or in Rajya Sabha. The bill can be introduced either by a minister or a private member and does not require prior permission of the President. So it does not require prior recommendation of the President. Like the state reorganization bills, it requires prior recommendation of the President. But this does not require prior recommendation of the President. The bill must be passed in each house by a special majority, that is the majority of total membership of the house and a majority of 2/3 of the members of the house present and voting, at least 2/3 of the member present and voting. Each house must pass the bill separately. In case of a disagreement, there is no provision of joint sitting as far as constitutional amendment bill is concerned. So whenever there is a disagreement with respect to any provision of the Constitution Amendment Bill, you can understand that between both the houses, that is the death of the bill. Because there is no provision of resolving a deadlock between both the houses by calling a joint sitting of both the houses. So in case of a disagreement between the two houses, there is no provision for holding a joint sitting of the two houses for the purpose of deliberation and passage of the bill. If the bill seeks to amend the federal provisions of the constitution, it must also be ratified by the legislatures of the at least half of the state by a simple majority, that is the majority of the members of the house present and voting. In fact, it is not written as simple majority, nothing is written, so that's why we are assuming that it is simple majority. After duly passed by both the houses of the parliament and ratified by the state legislature when necessary, the bill is presented to the president for his assent. But when he is presented to the president for his assent, the president must give his assent. He cannot return the bill like he does in the case of an ordinary bill. He cannot say that I will not sign the bill. He must give his assent. The president must give his assent to the bill. He can neither withhold his assent to the bill nor return the bill for the reconsideration of the parliament. What he does with respect to this, nothing but he has no right of absolute veto or suspensive veto. That's it. No right with respect to constitutional amendment bill. After the president's assent, the bill becomes an act, a constitutional amendment act, and the constitution stands amended in accordance with the terms of the act. Clear? So the procedure is very simple. I'm repeating it one more time. You can introduce the bill either in Lok Sabha or Rajya Sabha. You must get it passed in both the houses separately by a special majority. If federal features, ratification by simple majority by at least one half of the states. Then comes to the president. When it is presented to the president, president must give his assent. No provision of joint sitting as far as constitutional amendment bill are concerned. But I feel a new kind of question can be asked with respect to amendment of the constitution, which is which kind of changes or modifications would require only simple majority of the parliament, special majority, and then special majority and ratification. So modification of the constitution can happen in three ways. One, by simple majority by the parliament, but that is not amendment. Amendment of two types: amendment special majority plus ratification. Plus ratification only comes into feature when you are changing the federal features of the constitution. So let's have a look at amendment to the constitution, but this is not amendment actually, by simple majority when you are changing the constitution. These are not considered as amendment to the constitution. Admission or establishment of new states, that is article 2. Formation of new states and alteration of boundaries, areas, boundaries or names of the existing state. 3. Abolition or creation of legislative council in states. Second schedule, this is article 169. Second schedule, emoluments, allowances, privileges and so on of the president, the governors, the speakers, judges, etc. Quorum in the parliament. Quorum is that minimum attendance which is necessary for transacting legislative business. Salaries and allowances of the members of the parliament. Rules of procedures in the parliament. इसके लिए भी आपको कोई amendment करने की जरूरत नहीं है. Privileges of the parliament, its members and its committees. Most of the privileges are based on convention, but some of them has been codified as well. Use of English language in the parliament. Again, you do not go for a constitutional amendment for it. Number of puisne judges in the Supreme Court. Conferment of more jurisdiction on Supreme Court. Use of official language. Citizenship acquisition and termination. Election to parliament and state legislature. Delimitation of constituencies. Union territories, the formation or the abolition of the legislatures in union territories. Fifth schedule, administration of scheduled areas and scheduled tribes. Sixth schedule, administration of tribal areas. All of this can be done without following the procedure that is prescribed under Article 368. But what requires special majority of the parliament? The majority of the provisions in the constitution need to be amended by a special majority of the parliament, that is the majority of total membership of each house and a majority of not less than 2/3 of the members of each house present and voting. The expression total membership, look here, means the total number of members comprising the house irrespective of the fact whether there are vacancies or absentees. So keep that in mind. It means disqualifications and vacancies, they are not taken into consideration. The provisions which can be amended by this way include fundamental rights. If you want to amend the fundamental rights, you have to follow the constitutional amendment procedure prescribed under Article 368, but no need of getting ratification from the states. Directive principles of state policy. All other provisions which are not covered by the first and third category. First category, though we are calling it an amendment, but it's not an amendment under Article 368. In fact, you should not call it amendment. It is the first category of changing the text of the constitution. The third category of changing the text of the constitution is an amendment to the constitution. The second category of changing the text of the constitution is also an amendment to the constitution. The first category is not amendment to the constitution under article 368. So if you are making changes to part 3, part 4 or any other thing that is not included in the first group and the third group, that requires special majority. Clear? Special majority here also, you do not say that, you do not think that the states are totally sidelined, because you have Rajya Sabha, and Rajya Sabha is nothing but the representative bodies of the states at the central level, and therefore you know that there is this angle of federal representation even in this case as well. Anyhow, by special majority of parliament and consent of the states, that is ratification by the state, election of the president and its manner, because the president is not only returned from the center but also from the state legislature, so therefore he is a representative not only of people of India but the people of states as well. So that's why you need, if you making any changes to the election procedure of the president, you need the ratification of at least 1/2 of the states. Extent of the executive power of the union and the states, obviously think of what powers will be enjoyed by the central government and by the state governments respectively. Supreme Court and High Courts, distribution of legislative powers between the union and the states, state list, union list, if you want to make some changes into that. Goods and services tax councils like the GST. Any of the lists in the 7th schedule, representation of, it means it also includes the concurrent lists as well. Representation of states in parliament, that is nothing but the 4th schedule. Power of parliament to amend the constitution and its procedure, like how the states would be represented in the parliament with respect to, say, how many seats would be given to them in Lok Sabha, how many seats would be given to them in Rajya Sabha, and how the nature of their representation, all of that if you want to change, you need the ratification by the state. You just cannot do it, because then there is no federation but only a unitary form of government existing. Power of parliament to amend the constitution and its procedure under article 368 itself. अगर आपको article 368 itself change करना, सब कुछ change कर सकते हो आप, तो बस इसको change कर दो तो, that would also require ratification of at least 1/2 of the states. So keep this in mind, that these are the two ways of amending the constitution: special majority by consent. Clear? And the third way is only of modifying the text. It is not considered as amendment to the Indian constitution.